This is our next session. Really, we've already had a great conversation so far. I'm excited about the next presentation as well. We have Will Rinehart from the American Enterprise Institute that is presenting now. Will is a senior fellow at the American Enterprise Institute, where he focuses on political economy of technology and innovation. His research covers policy areas such as diagnostic testing regulation, federal agency regulatory guidance, the CHIPS and Science Act, and the regulation of artificial intelligence. He also serves as an expert at the Federalist Society's Emerging Technology Working Group, which is part of the Regulatory Transparency Project. Before joining AEI, Mr. Rinehart was a senior fellow at the Center for Growth and Opportunity at Utah State University. He was also the Director of Technology and Innovation Policy at the American Action Forum, a research fellow at Tech Freedom, and the Director of Operations at the International Center for Law and Economics. Additionally, Mr. Rinehart worked for the Progress and Freedom Foundation, focusing on advertising policy and internet governance. The Illinois Policy Institute, where he studied state-level budget, energy, and tax issues, and the Institute for Policy and Civic Engagement at the University of Illinois, Chicago as a research assistant in technology and civic engagement. Mr. Rinehart was a fellow at the Internet Law and Policy Foundry and Frederick Bastiat Fellow at the Mercatus Center. Additionally, he served on the Federal Communications Commission's Broadband Deployment Advisory Committee and Consumer Advocacy Committee. Mr. Rinehart's work has appeared in the Wall Street Journal, Bloomberg, Wired, Morning Consult, The Hill, Forbes, Reason, Marginal Revolution, and Overlawyered, and on BBC Radio and NPR, in addition to other broadcast media. He speaks regularly on topics related to tech policy, has been cited in regulatory orders from the Federal Communications Commission, and has been featured in the Supreme Court petitions. Mr. Rinehart has a MS in Applied Economics from Johns Hopkins University and a BA in Political Science from the University of Illinois. So as you can tell by his extensive resume, he's very qualified to talk about AI regulation. I'm really excited to hear what he has to say. Let's all welcome Mr. Will Rinehart.
Is it on? Yeah, there we go. Look at that. Hello, everyone. Don't think ill of me because I'm from Illinois. That's how I want to start off this conversation. But actually, I want to start off with something that I think kind of struck me. Right. So imagine, for example, you got up in the morning and you're going to work. You start, working on a project, and you end up, opening up your Excel spreadsheet, and you're like, I really want to change this number because clearly, we got an update recently, and you realize, actually, I can't do that. I have to go ask every single person in my data spreadsheet if I can update this. This seems like kind of like a weird thing to suggest and even imagine, but this is actually what a state AI bill from California suggested. It was what's called AB 1018. And the State Water Board specifically said that they were worried if this bill in particular were to be passed, that they, wouldn't be able to use Excel spreadsheets. When they went to update them, that they would require a whole bunch of approvals from every single person in order to actually do this. And the reason I'm suggesting this, right, and this is the bill, AB 1018. This is something I was following very closely. The reason I'm suggesting this is because fundamentally, this is really the kind of the bulk of my talk today, which is a lot about this relationship between these regulatory structures, between a lot of these new bills. Thankfully, this bill was not passed, but there's a lot of bills that are being suggested in the state level. There's a lot that's going on the federal level. And what I'm really seeing is a lot of conflicts. So I'm going to spend a little bit of time today. I also speak kind of quickly, and I originally prepped about 45 minutes with like 15 minutes of talk. So if I go quickly through some of this stuff, we're going to need some more questions and answer session. But don't worry, I used to teach, and I can start picking on people and ask for very specific questions. But I think this will, I think this will get the blood moving here a bit. This is something that I think is very interesting. I think kind of exemplifies the actual tension we're seeing here, right? This is Scott Wiener. He is currently going for the state Senate seat, and we'll see. So I'm sorry, not state Senate, but federal Senate. He's currently a state senator. He has been one of the people, and we'll talk about him here shortly, this bill that he's passed. But basically, I think this is very indicative of what's actually going on, broadly speaking, within the state level policy, right? That we have an opportunity to apply the hard lessons we've learned over the last decade as we've seen the consequences of allowing unchecked growth of new technology without evaluating, understanding, or mitigating the risks. He's clearly talking about social media, right? Like he's talking about social media and the problems that we've had with social media. And what I think is very interesting is that effectively, this I think is kind of the mentality of a lot of legislators now, right? That we didn't really do enough with social media, and we really have to get ahead of these things, or we have to get ahead of this thing, right? But I would make a comparison here between this mentality and something that was generally considered bipartisan back in 1997, right? Admittedly, that was 1997, almost 30 years ago. But Clinton had this, what was called the Framework for Global Electronic Commerce. And he said, where government involved is needed, the aim should be to support and enforce predictable, minimalist, consistent, and simple legal environment for commerce. This, I think, is really where the reason I'm bringing this up and the reason why I'm trying to compare these two is because we really have seen a shift. I've seen a shift specifically in the last really 3-4 years on how people are understanding AI laws and really the drive to do something on AI, right? It feels like people, think that we kind of messed up with social media, which I don't really think is the case. But there's a lot of drive to do things today in a way that I just have never seen this before. So today I'm going to talk a little bit about, this is generally my talk a bit, right? So 3 things I'm going to hit on. The bulk of it's going to be on the second section, which is state laws and federal laws, and kind of going through the various state and federal level fights, and there have been a lot. But I'm going to start with this idea of 3 frameworks, 3 ways to think about these problems, 3 general ways to think about problems. And I'm going to end with some of the projects that I've been working on, something I'm really excited about right now, which is using LLMs for cost compliance estimates. I think that there's a lot of benefits, and especially if you're, a researcher, you're in political science, you're in economics, I think there's a lot of things that we can be doing with these tools, and I kind of want to, suggest it and try to get those ideas also going. So the reason why I'm starting with frameworks is actually because of something I read a couple years ago. Well, not a couple years ago, decade ago, 2 decades ago, from one of the people who's going to be talking early next year, Deirdre McCluskey. She's actually one of my professors at University of Illinois, Chicago. And when I read this original piece, it kind of floored me. It was 20 years ago that I read this, now I'm thinking about it. But she said, I think very artfully that, the market for apartments in New York, says The Economist, is just like a curve. And I think that's actually what we want to think about when we're thinking about frameworks, right? That these metaphors or models or frameworks, they really help us to try to understand things that are going on in the world. And, the way that you can try to understand the world is to try to create a lattice work of these different things. So I want to give you at least 3 different ways of thinking about understanding AI currently. Now, admittedly, these are flexible, and but I think that this can help try to understand this problem more writ large. So the first thing I would suggest is what I'm calling the AI regulatory stack. There's this conception out there that, Congress is doing nothing. The government's doing nothing on AI. Well, I don't really think that's correct, right? And I put together what is called the AI regulatory stack. I mean, there could be a better term for this, right? But effectively, when you look at our regulatory system that exists currently, we have so many different ways of actually going at these problems, right? We have financial regulation, we've got insurance and accident compensation regulation, we've got product recall law, we've got data privacy laws, we have consumer protection laws. There's a whole bunch of different ways that you can get at this problem. And when people really talk about AI bills and AI laws, I think that's the first thing you should be suggesting, or at least thinking about, right? What is it that we already have that we can extend? Because oftentimes when people talk about new laws, there's a lot less discussion of perhaps doing more enforcement, right? That currently what we could do instead of, say, pressing, and there's been a whole bunch of these cases, right? There's been literally hundreds of actions of the federal government, from the Food and Drug Administration, from the FTC, from NIST, from the Department of Education, right? There's been a whole bunch of these things. I've literally been collecting them, and I have a website that'll be going live early next year. There are literally hundreds of these actions, right? Through the FTC, through the FDA, through a whole bunch of our current regulatory structure, we're doing a lot. And I think that that's not well appreciated, which I hope would be understood. But fundamentally, government may be slow, and I think people kind of think that Congress is not doing anything, but really Congress is, I mean, maybe Congress can help here, but a lot of the mechanisms are already in place. And you know, a big one, which I'm not going to talk about today, are all of these copyright laws that are currently going through the courts. I think there's about 52 of them, right? They're all over the United States. There's a whole bunch of these that could fundamentally change how each one of these companies works, right? Anthropic, right? You'll notice some of the big players here: Anthropic, NVIDIA, ChatGPT, Meta. Like literally every single major AI company is currently in some sort of major copyright or IP law or a case, rather. I think that's going to be a huge determining factor of what actually goes on. But to get really back to the point, that there's a lot of these things that are happening all at the same time. Meanwhile, I think personally that there is this really big issue that's happening between what you would call the West Coast and the East Coast, right? And the framing I like to talk about is through that old Kipling quote, right? I mean, Kipling has his problems, but I've always thought that this quote is very indicative and very helpful as a way of framing this problem again, right? That the East is East and the West is West, and then never the twain shall meet. That really, when we're talking about a lot of these problems, I think that to really understand them fundamentally, you really need to think through the fact that there really are multiple different conversations going on in Washington, D.C., in state houses and other centers of power, right? What I think about the East. The focus is on AI. A lot of it is on regulatory scope, legislative action, law, litigation. But in Silicon Valley and Palo Alto, fundamentally, it's very different, right? There are two different cultures, as the old, C.P. Snow book suggests, right? There are two different cultures that are going on here. One is happening in AI, in the centers of AI. Another is happening in the halls of power. And why I think that's important is because of something I've talked about more than a couple times is, would it even be constitutional when we're talking about some of these laws? There was a suggestion in 2023 actually, but I wrote about it a year later. Would it even be legal to pause AI? This is an idea that was proposed and signed by Elon Musk and a whole bunch of very well-known tech entrepreneurs. But I kind of looked at and went through a bit of the law that currently exists, and admittedly, there's no real strong Supreme Court case. There's a whole bunch of district courts. But fundamentally, like, this is just something, whenever I ask somebody about the laws and legislations that they're proposing, would it even be constitutional? And I normally find blank faces, especially when I'm talking to people in Silicon Valley. And the reason why that's important is because if you do care about these things fundamentally, you do need to be attendant to the public policy, right? You do need to know about the law, about the ability and the limits of legislation. And I think that's also a bit of a problem, as you'll see as we start talking about some of these laws, is that if you're not, we're racing ahead to pass a lot of new legislation, but it could bump up against the courts, right? That we could have this really interesting court fight that might happen. We might also be doing things and pushing for legislation and not really understand how this piece of legislation that is passed integrates with the rest of the legal system, which creates very big problems and lots of really big fractions. That's why fundamentally the way I think that we should be thinking about AI is not regulating AI as a tech, but regulating AI uses. We don't really regulate software, right? We don't. There's no like software regulation. We regulate how software is used in finance and health and housing, right? The focus, my personal focus, when we think about these three frameworks, my real thing is that we should be thinking about AI uses and regulating AI uses, and not necessarily regulating the technology itself. This has a bit of an old pedigree, interestingly enough. There's a very well-known law professor, Frank Easterbrook. He wrote this piece back in 1996. It was called The Law of the Horse. It's generally called The Law of the Horse, right? And he preface this by saying, we didn't develop a law of the horse. We developed all of these other things related to the horse, when technology was advancing from the horse to the car, right? And I think that's a very similar thing that we should be thinking about now, right? And the entire point of his piece, which I'd highly suggest reading, I think it's actually very helpful to reimagine, to rethink, because many of the same conversations we're having now with AI were existing back in the 1990s with cyberspace, as they were calling it, but it really was the internet, right? It was the beginning of the internet in 1996, 1995. And so what he talked through is, what you need to do is develop a sound law of intellectual property and then apply it to computer networks, right? The thing that we need to be thinking about are all of these other the principles that go around the laws that we're trying to enact, and then figure out how they then interact with the uses. That I think is not very well appreciated currently. And I think that what we're seeing, and unfortunately, I think is going to be a big problem in the next coming years, is really these frictions that exist between the states and the federal government, and this idea that we need laboratories of democracy. So, yeah, laboratories of democracy. Right now, I'm hesitant to, obviously we do need laboratories of democracy, but there is this tension I see, and a tension that I have within all of this. We take, for example, I kind of suggested at the very beginning, but social media, right? Social media and privacy legislation is something that I think 19 different states have passed. When you look at the different state level implementations of privacy, it is incredibly difficult, even if you're a company like Meta or Google that wants to comply with them, that because of the nature of the internet, right? Because it traverses lines between, between states, that it's incredibly difficult for even these companies who want to be compliant to understand where their compliance truly exists. And so I thought that it was very interesting. I was actually talking with somebody who is a, basically public policy leader. He was one of the chiefs of staff of a major, multi-billion dollar firm. And he said, speaking about this problem within privacy law, that there's so many different states that are interacting. He said that will be defensible, right? We can defend a lawsuit, but we don't know if we can ever be compliant. And that's because to be compliant is actually very difficult, because they don't know, whenever they send a piece of information through the internet, right? They don't really know how it's going to be routed around through the internet. So if you have multiple different states that are regulating in slightly different ways, right? And the privacy definitions are slightly different in New York than they are for California, that as that information gets routed across the internet, then in fact there are conflicts that they don't know if they'll ever be able to resolve. But at the same time, I think that we do need to be understanding that AI and other technologies are new, and we do need to have some sort of ability to kind of figure out where the tensions lie, and whether or not we should apply, this idea, an idea, for example, on safety, or an idea on, say, bias. And so to me, there is this inherent tension that I think that we really, it's okay if these things go unresolved, but fundamentally, this is the tension right now that we're seeing, is this tension between the states and the federal level, and the question of whether or not we really should be emboldening laboratories of democracy, because there truly is a cost, which I'll get into at the very, very end. But what I want to do here is just kind of go through a bit of the last couple of years in what's happened. So I have two slides here trying to go through the history. So October, so almost 3 years ago this month, right? So it was November 30th, November 30th, 2022, ChatGPT 3.5 becomes public. This obviously happened during the Biden administration. And I think what's interesting is that the Biden administration already released a blueprint for an AI Bill of Rights. And it's really kind of fascinating to see the total trajectory, right? I've been working in AI issues now for 10 years, effectively, working primarily in early level understandings of AI job loss. There were a lot of reports back in 2013, 2014 that AI is going to take a whole bunch of jobs. And so as somebody who was working in economics, I just did huge deep dives in trying to understand these reports. But what was interesting, especially starting in about 2016, 2017, is you saw more and more interest in doing something on AI, right? But fundamentally, it really is not the AI that we're now very used to. It is not ChatGPT. It was predictive AI. It's algorithms that are used for housing and for loans and for, rentals. So it's a whole bunch of other algorithms that are connected but are not the same as the AI that we're talking about today. I think that's happy to discuss more about that. But when Obama came into office, one of the things that they ended up working on was this blueprint for AI Bill of Rights that really was all about predictive AI, as we call it, right? So you can separate out predictive AI and generative AI. Predictive AI is the kind of stuff, as I said, civil rights, housing, Fair Credit Reporting Act. Those are mostly in the kind of the predictive space. November 2022 happens, and then within a couple months, ChatGPT reaches 100 million users, becoming the quickest commercial technology that's ever been adopted. And pretty soon after that, then the Biden administration ended up signing their executive order on AI. And by the end of that year of 2023, you had roughly 200 bills that were introduced across state legislatures. More recently, this is really ramped up, right? So February 2024, California's SB 1047 was introduced. We'll be talking about that here in a second. But what's interesting, I think, is also important to note here is, for example, the European Union, they actually adopted their act in 2024. They had to make amendments in 2023 for LLMs because this regulatory structure that they had, which has been adopted and it was also embedded within the Biden AI blueprint for the AI Bill of Rights, that had this idea, and basically we kind of had this notion of what we should do for AI, and then we applied generative AI on top of it. Pretty quickly within that same year, last year, Colorado's AI Act was signed into law. The California's SB 1047 was eventually, it was passed by the California legislature, and then it was vetoed by Governor Newsom for very specific reasons. But by 2024, we'd seen over 600, something like 650 AI-related bills, 100 of which were enacted. Earlier this year, right, and I'm just thinking about now we're in November, and it feels incredibly close, because I remember very clearly when Trump rescinded the Biden executive order and really started this entire new interesting fight that happened beginning this year. I'm going to talk a bit about the AI moratorium, but that happened in May, June, and July. And then July, we have an AI action plan is published. And now currently, I've actually been tracking these. We have about 1,000 bills in the state legislatures across all 50 states. Things have changed very dramatically. Though there are only a couple different, structurally, there's only a couple different types of these bills. We have basically what we would call study bills, right? We have a group called sectoral regulation, the real things to think about and to focus on are these other two parts, which are the safety and then the bias and fairness bills, which I'll get into here shortly. But first, a bit about the study bills. This is mostly what was happening in 2023 and 2024. Committees to understand AI. I think that's actually a very good thing to understand, right? You commission reports, you figure out where the gaps are in your legislation, and you start trying to extend or plug those gaps. Right? When we write sectoral legislation, right, there's a whole bunch of stuff that doesn't necessarily apply to AI, but should apply to AI. So, for example, Arizona's SB 1359 prohibits deceptive or fraudulent deepfakes, right? You can't. There's a whole bunch of regulations on what you can say about a candidate, but they just extended that to deepfakes and said you can't do a deceptive deepfake. So you apply the idea, the notion, right? You regulate a use, but you extend it into this new space. So these sectoral laws, a lot of stuff that's been happening, a lot of what's been going on at the state level, a lot of them have been extensions of that. The one that I would highlight are the behavioral health laws. This is something I've actually been writing a lot about because it's been interesting to see how this is actually traversed, because you have Utah, which actually did kind of what, as I suggested, right? Utah had limitations on what behavioral and mental health, practitioners and people who were licensed, what they could do. And they basically just said, everything that applies in the real world also applies if you use an AI system, right? We're not going to really change things. Illinois was very different. Illinois basically banned any usage of it. So in Illinois, you cannot use AI to diagnose, treat, or improve an individual's mental health or behavioral health. And the interesting thing about that is, if you think about apps that do this, it is all of your health tracking apps. It's all of your, if you're, as I do, I track my workouts. Anything that is related to like wellness. So, if you're using a wellness app technically does improve a mental health, right? And so those things would be regulated. I think that this is something I've suggested that they need to clean up, but I think that this is indicative of what we're seeing within the overall state legislatures, which is that these ideas, which potentially could apply and might be good, right? Maybe we do actually want to ban AI for any sort of use within mental health. But perhaps we don't want to include all of these other uses and functions. But because there's this demand and because there's a push that we need to do something on AI, the really important parts of the law are not getting attended to. And so therefore you end up passing something, and this was universally supported. It was signed by the governor. But yet there's very serious questions right now whether or not a whole bunch of these apps would actually be able to exist. And they're probably gonna have to go through and rewrite parts of the bill specifically to cut that out. But this, to me, I think is really what we're seeing. And I think this is actually quite indicative of this general problem. The other sorts of things that I would also highlight and that should be interesting is like a new area where I just have never really seen a lot. I mean, there has been kind of interest, but algorithmic pricing, I think, is a very, very, very interesting area. It's something I'm going to actually work on in the next couple of years. It really, you've seen a lot of this, right? Like rental pricing, there's been a whole bunch of cases on whether or not you can use an algorithm for rental pricing. Again, this goes back not to generative AI issues, but much more this old school algorithm, what's called predictive AI. But algorithmic pricing, there's been a whole bunch of new regulations that are going to be coming out. A whole bunch of stuff has already been approved. Illinois had one, Vermont had one on restrictions of dynamic pricing in retail. There's been a whole bunch of these changes that are also coming. So it's something to pay attention to if you're interested in this largely. But for the bulk, what I really think that you should be focused on, and what I really think that is the most important part, are these two types of bills, right? What we call a safety bill, and then maybe like a bias and fairness bill. And to me, there's really two different indicators: SB 1047, which did not pass, and then Colorado's AI bill, which did pass. I think they're very indicative of kind of what we're seeing broadly speaking at the state level. So this, as I opened up this conversation with a quote from Scott Wiener. He's the one who pushed this bill, SB 1047. And eventually this did pass, but so this did pass, and then he pressed for a new bill later this year, which did in fact get approved. But this bill, SB 1047, was the first what you call AI safety bill, right? We're concerned about what's going to happen with, say a Terminator scenario, or that these advanced AI technologies are able to open up or able to attack computers, right? That we're worried that these things could help malicious use. And so what we're going to do is we're going to restrict it, right? We're going to put in certain provisions within the law to allow these things to be safe. This did it through what was called a compute threshold, right? So what we end up doing is we say that basically any large model over this certain threshold would be covered by the law. This is like a very wonky definition, but it is actually used pretty consistently. This is actually what the Europeans use, a version of this. But this, at least the 10 to the 26, hasn't been reached yet in the United States. We think the next generation will hit this. The Europeans use one level lower. So basically all the newest technologies currently. So your ChatGPT 5.0, basically all of the current Claude and Anthropic's Claude, like all the 4.0 stuff or the 4.5, that's all regulated under European law. But basically what they end up doing is adding this compute threshold in order to, be the way in which you regulate the entity, the AI model. The weird thing, it's also the other way you can kind of do this is also through training dollars, right? So they basically say, if your training runs cost $100 million to run, then you're regulated under this law. I think that's potentially a really interesting problem in the near future as training runs potentially become cheaper and you spend a lot more time on the other end But needless to say, what was interesting about 1047, the reason I was so interested in it was originally because it had this provision called, you have to build in a kill switch, right? And I'd written a lot about the legality of pausing AI and even pausing a kill switch. Provisions of this ended up getting kicked out at the very, very end. So it was slightly different. But broadly speaking, this is what a lot of the safety bills look like, right? You have to conduct an annual review. You cannot initiate a covered model training if there remains an unreasonable risk, which is a very, I don't know if you have any lawyers in the room, but reasonableist standard is like it's like basically a hole. We don't really know what it means, and it has to be determined by the courts. So this, I think that what was interesting about this bill in particular is that it added a whole bunch of different things, right? That maybe perhaps on one provision or two provisions we actually would want to do, right? Perhaps we do want to actually have, cybersecurity protections, right? I think that's not a bad idea, right? Obviously, we need cybersecurity protections. What that actually looks like as far as a provision and what the laws look like, I think that matters a lot, right? But perhaps, but then you add in, you have to have a kill switch. Is that legal? That conversation, quite literally, I bring this up consistently. No one really seemed to care whether or not that their bill would be sunk because it was, fundamentally in conflict with the First Amendment. That didn't seem to really get a lot of interest, which again, I would hope that it would, but it is what it is. But fundamentally, there was other things that also existed within SB 1047, which I think were interesting, right? These know your consumer provisions, they actually probably violated the Federal Stored Communications Act. So this is, again, you have these conflicts, right? The states are trying to do certain kinds of bills, but they are fundamentally not being considerate of how they interact with the federal level. And then there's also just this general thing where they just kind of pushed it off to this frontier model division to define the rules. This is actually something we've seen pretty consistently. And it's in fact something that happened with Colorado's AI Act as well. So this is the other major AI Act that I think is kind of indicative, like as a framework. Colorado's AI Act doesn't really consider itself with safety, right? It's not really worried about cybersecurity attacks or producing kind of the Terminator scenario. What it's actually worried about is how to implement and regulate high-risk artificial intelligence systems that are making consequential decisions. So the first thing I started with, that original law talking about how it would limit Excel, that's basically the framework of what Colorado implemented. It includes a whole bunch of things. So it includes education, employment, financial services, but it doesn't include actually a lot of stuff that are currently being talked about now. So it doesn't include chatbots. It doesn't include anti-fraud and virus tools or AI video games. A whole bunch of stuff that actually is in the conversation right now about being regulated under Colorado's AI Act. They would not have been regulated under that. It was kind of similarly, though, and this is what's interesting, right? It actually kind of similarly had a whole bunch of different sorts of provisions that kind of looked very similar to SB 1047. So there was, specific items, right? It required reviews, impact assessments. These were actually very similar. SB 1047 required something very similar. But what it also included were a whole bunch of other things, right? So making publicly available statements, summarizing the high-risk state or the high-risk uses, providing a consumer with the opportunity to appeal. It included a whole bunch of other things. And I think the real takeaway here is that there's really kind of two ways in which states are considering and regulating AI, and each one of them is slightly different, right? The thing that I saw really about Colorado's AI Act is the problems that occur with actual enforcement. What was interesting to see, and having tracked this now over the last couple of years, Colorado estimated actually a pretty minimal fiscal impact. So I don't know if anyone here really looks at fiscal notes, but typically most states do them. I think 47 states. I know North Dakota does this, right? You have for the big bills, right? You have a fiscal impact statement, generally speaking. Their original fiscal impact suggested that we could do this with, so basically like before a bill is passed, you want to understand like how much is it going to cost for the government to enforce this. They initially said, well, we could do this with existing appropriations, right? And then right before it was passed, they said, it's actually going to cost about $650,000 per year to enforce. Then this year they did a re-estimate, and it's now going to be between 2.5 million to potentially Governor Polis is suggesting about $6 million a year to actually enforce this. They're considering a very major overhaul of this entire system. So the idea is great that you want to protect consumers. And I think that everyone generally agrees with that. But when you get into the black letter of the law, it matters a lot. And this, to me, I think is something that is just not well appreciated. Not surprisingly, Polis is actually one of the few governors to support this idea of an AI moratorium in Congress earlier this year, because it would give Congress time to figure this out. This is probably the biggest thing that's happening right now currently, and the reason why I actually had to update a couple of these slides. So earlier this year, we had this big, huge fight over the AI, what was called the AI moratorium. And this idea is basically that you would have a 10-year, so initially it was going to be about 10 years, right, that you couldn't have very specifically targeted AI legislation in the states. The idea was basically to, and it couldn't be just specifically targeted on AI. Now you could have a whole bunch of stuff for kids' safety. You could have a whole bunch of things for discrimination, but you couldn't be specifically applied, right? It had to be general applicability, as it was known in the provisions. This would have stopped effectively any of those state bills specifically directed. So it would have really stopped most of the safety and AI bills that I was talking about earlier. This became an interesting fight because originally there was an agreement. It went through the reps, and then Marjorie Taylor Greene, NTG, started really making a whole bunch of hay about it. That then ended up, Steve Bannon on one of his shows ended up really talking about this issue, and it basically killed the moratorium. Where the reason why this to me is a very important piece of the entire conversation, because what's effectively happened is that this moratorium, the AI moratorium during the Big Beautiful Bill, One Big Beautiful Bill, really has changed around the politics at the federal level on all of this, right? So you have somebody like Jared Polis who really sees fundamentally, hey, he was kind of forced actually to sign the bill. The state leaders basically said, if you don't get your housing bill, if we don't get our Colorado AI bill, then you're not going to get your housing bill, because he wanted the housing bill. He approved the AI bill and had the most interesting signing letter and basically said, I don't think that this is a good bill, but I'm signing it anyway. And that's because, effectively it was politics. He wanted to get his housing bill finished, but he also understood implicitly, he's one of I think he's actually it was very sad to actually see him sign the bill, because he's been in Congress before, right? He was a congressional member, and he was, I think, one of the better tech people, right? He had done a whole bunch of really important provisions and laws over the last couple of years. But he really has seen that it's very difficult to actually do this in practice, right? That we have very high level notions of where we should protect consumers, but when it gets into the nitty gritty, there's a whole bunch of conflicts when you actually try to mandate a bias and fairness bill, as they're generally called, for the state level. However, this is back. So literally earlier this week on Monday, I heard about this late last week. The House is currently eyeing AI preemption in DAA, right? So for those who don't know too much about laws, there's really only a couple must-pass pieces of legislation. The NDAA is one of them. All right, this is the Defense Act. That's the National Defense Authorization Act. This has to happen every single year for the defense budget. The reason why it's important is because, again, it's a must-pass piece of legislation, and sometimes if you can get agreement between everyone together, that you then can pass something that, people don't like it because it's like log rolling, or it's putting something within, other piece of legislation. But when you only have so many vehicles that must pass, oftentimes this will become an area of conflict. So that was on Monday, and then what date is that? The 19th, so Wednesday, it was then released that the White House might do an executive order on preemption. So that was 2 days ago, right? It seems right now that probably the NDAA is dead, but probably also the executive order is dead. It's interesting to really be somebody who's been working on these issues, and quite literally in a span of a week, literally a couple days, to then be presented with the fact that we may get, in fact, an AI piece of legislation, right? We don't have a federal privacy bill, but there was a moment where I was considering the fact that we would have a federal AI bill, and not a federal privacy bill. The federal privacy bill has been fought over for many, many, many years. But I think what Trump was really suggesting and thinking about through this, and specifically through the EO has been pushed back, that, you know, he would use his power to basically preempt the states, and that would then give basically a forcing function event to then cause the legislators to come together on NDAA and basically have an AI bill. I never thought that, you know, I was skeptical because unlike the, you know, so I've talked a little bit about privacy and social media. There's been kind of large scale agreement on what that should look like for many, many, many years. The real tension has just been on basically like 2 points within privacy, within a national privacy bill. We just don't see that within AI bills. That really we see this tension between safety, right? People who want to do something on the Terminator scenario for AI and for ChatGPT, as compared to people who want to do something on algorithmic bias, you know, reducing certain high risk categories. And those two things really, there's not you know, there's not a lot of agreement on what a bill should look like that combines those two. And I think that that is the reason why you aren't seeing a lot of agreement on what a federal privacy bill should be. But we'll see what happens with the executive order. The executive order, at least it seems today, as I was reading, that it probably is going to get pushed back past Thanksgiving. Meanwhile, state legislators are gearing up for massive battles this next year. I am also kind of gearing up for massive battles next year. There's a whole bunch that's going to happen. So again, going back to the, you know, the pricing stuff that we talked about and a bit on the behavioral health, I think is going to be a big issue. So all of these areas that we've talked about, safety and bias and fairness, all of these things are going to be coming ahead this next year. The politics are very, very different. You know, Virginia, for example, had a bill that was passed. Virginia had a Republican governor. Now they have a Democratic governor. And so I don't imagine that you know, that the same bill that basically didn't pass the governorship last year is going to do the same this year, probably will get passed. If you're interested in this, happy to talk more about it. I would suggest, however, which is something I've suggested to all of my RAs and former students, do vote counting. It is really tough, but put out a spreadsheet, because it's not illegal, thankfully, and figure out every single individual that would support a committee or be on the committee, and actually figure out how they're voting, or like just try to give them a number, right? They're like probably a yes or probably a no or kind of uncertain. When you actually start doing that and forcing yourself to think through this structurally, and I don't think a lot of people do politics structurally enough, right? That it has to go through committee system, right? Generally speaking, it has to go through committee system, but it's all of those things that really combine together, right? The committee systems, it has to go through one house, right? You have to have agreement generally with the leadership. So start trying to, if you're interested actually in politics, the thing I would suggest is do vote counting, right? Figure out, you know, if it's a piece of legislation that's in the environment and you care a lot about energy and the environment, who are the people that are leading the energy environment committees, right? And how can that thing then go up or trickle through the committee process, then up through, say, the House and through the Senate? Doing this for every single state is incredibly difficult. It's something I'm trying to actually automate. And that brings me to my last part, which is using LLMs for cost compliance. I think this to me is probably an area where it's something I'm working on pretty extensively. And I think that a lot of these tools, what's so cool about them is you can really do quick coding. You can do a lot of really interesting things very, very quickly. But this project, generally speaking, came from this idea that I saw, or this you know, this paper I saw late last year. This is generative agent simulations of 1,000 people. And what really, really struck me about this is that they were getting the General Social Survey, right? So the General Social Survey is this long-standing poll that University of Chicago's done. They got it accurate to about 85% of the time. That's fascinating, right? So they did extended surveys and asked questions of individuals. Each one of those then was created a persona, a profile, and then they asked the questions of you know, they asked them questions of those profiles, and they were actually, you know, pretty good when it came to the surveys. I think this is going to be a really interesting area for especially researchers like myself to understand how things are moving. But I think that fundamentally what I really wanted to understand is, what if we applied this idea to regulatory cost estimates? I do a lot of cost compliance estimates. So I just asked, I asked ChatGPT, act as a compliance officer at a regulated company, and assess these provisions. And then it provided me, and I basically pulled together all of the material. It provided me this really kind of interesting graph, right? Which is, you'll notice here that these are 3 different provisions. These are, so we have data on these, right? So you have, the first one is a risk assessment provision that was done by California. The second one was an automated decision-making technology regulation done by California. And the last one was this BIS rule. So we have this data, and that's what's on the first line on each one of them, right? Which is so for the first 2, which are from California, right, the standardized regulatory impact assessment the first year and then the subsequent years. So we have official state data on what the estimates should be. And then I re-asked the exact same question using the exact same provisions of the law to see what the LLM suggested. What's interesting about this, I think, is that, the LLMs weren't all, they're not like perfect, but they're not like completely out of bounds, right? ChatGPT for the first year is, kind of right in the middle of where it suggested what the cost would be, is exactly what the official estimates were. And you see, especially for that second California law, which is under the ADMT section, right? It actually put it at a little bit less. So what's interesting is we're seeing is that these regulatory, the LLMs are kind of getting relatively close to official numbers. What's actually very different is that the subsequent year numbers are almost completely, they're almost always larger. And I think that was very, very indicative of the problem, because typically when you do these standardized regulatory impact assessments or like these official numbers from the government, that you basically just kind of, you take them as a percentage. And that's not really that good, right? Because you may do something initially and you'll have like initial costs, but your fixed costs are actually, they're not just a pure percentage. They actually have certain kinds of requirements. From here, I then took it, obviously, as because I'm an economist, you do discounted regulatory cost analysis. So you figure out what the actual cost is fundamentally. Right, so this is done over 10 years, done with a 2% discount rate, very, very common, right? This is a common way to do cost impact assessment. And I think what these showed is that, these are the SIRAs and then the ADMTs. This is from California. This really showed that the estimates from the standardized regulatory impact assessment, because they do kind of a couple of these, right? They do scenario analysis, right? They basically say, well, it could cost this or it could cost this. They do a high level and a low level. But what we're showing and what's interesting is that basically a lot of these provisions are pretty close, but the bounds are much, 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 much larger. My work in the next couple months is actually going to be to go through and to redo this. So this is something I'm currently doing, right? You basically make what are called personas. You say, hey, the industry is, you differ between the industry, right? The industry, say, is retail as compared to technology. It has different kinds of resources. You have, say, an in-house legal counsel. And then what you can do is you can take this with what we know with what's going on in an actual state or in the federal government, and we can start narrowing all this down and doing a whole bunch of fine tuning. So one of the big projects I'll have in the beginning of next year is taking a couple different looks at this, right? And trying to get better and better such that we actually get pretty close estimates to what the official numbers suggest. But I think that we really can be doing and using a lot of these technologies much, much more broad-based, especially people that work in business. There, I think, is a really, really interesting opportunity to use surveys, active surveys, to ask your local businesses and say, hey, like, here's what it looks like. You ask them and you do the kind of the initial report that I suggested here. And that way you can actually do something very, very localized, right? That if you have a new tax provision that comes in, or you have a new regulatory provision, you can actually have something that's incredibly local to your community or to your state. Happy to talk about this further, but that's the end of this. And I know I've thrown a lot at everyone, and I think we have about 10 minutes. So yes, happy to take questions.
Please raise your hands.
Thank you, Mr. Rinehart.
Yeah.
If you would, can you go back to the Biden executive order from 22, compare that to the Trump outline that was issued in 25, And then tell me, who advised these presidents in this matter?
Yeah. So Biden's the Biden executive order, the guy who mainly wrote the executive order under Biden is a guy named Ben Buchanan. The big difference between I mean, there's multiple differences between President Biden's executive order and then Trump's executive order. Biden's executive order, one of the big things that is a big difference, and one of the issues I had with it is that it used basically what's called the Defense Production Act, the DPA. And so it used that authority, and this is typically for like surveys. This is a bill that was passed during the Korean War that was meant to, energize the use of local industry for the Korean War. What's interesting about that is that he took the furthest extent that you could for that bill and said, if you're an AI, a big model provider, right? If you're ChatGPT or Claude, you have to provide surveys. You have to provide every 4 months. You have to provide us information about what your models are doing, right? What's interesting about that got a lot of consternation, and it was actually the BIS rule that I mentioned at the very, very end, right? That the provision that we do have regulatory analysis for, because the state itself, or I'm sorry, the federal government went through and did analysis to see how much that providing information on what your models are doing anytime your model updates, that was actually pretty costly. I mean, at least we can look at the numbers. All that's to say is that I think that the big difference between the executive order from Biden really is the extent at which it was using the authority of the Defense Production Act to push for understanding of what's going on with frontier models. There were other things that were clearly different between the two. Another big thing that I think that really where the Trump administration kind of flubbed was they didn't create very specific timelines. So with President Biden, there was I think something like 180 different reports that had to be created, and a lot of that was just figuring out where the gaps exist. So a whole bunch of stuff on financial regulation, and for example, what the FTC could do, as far as regulatory provisions were concerned. But all that stuff has been produced, and that's actually most of it's still online. So what's interesting about the differences between the two. So once Trump came into office, he got rid of it. Literally, second day, he got rid of the executive order. What we have now is actually it's not that different, interestingly enough, except for those Defense Production Act provisions. They look very, very similar, right? They're suggesting we should do quick permitting for data center use. That was something that Biden had also suggested. It was kind of a whole of government approach, right? The big difference between the two, I think, would be immigration, right? Obviously, there's nothing basically on immigration in Trump's provision, whereas there was a lot of suggestions within the Biden executive order. But I think the broader way to think about this is that executive authority is actually somewhat limited on what it can do, right? I was working with them trying to think through what their next round of regulatory actions could be, because they just put it out, or they just closed their a recent kind of deregulatory docket, as it's called. And I think what's interesting is just that a lot of stuff you'd actually want to do is going to have to be approved by Congress. So fundamentally, there are changes that really are pretty distinctive between the two, and I'm happy to talk about it more, but they kind of look very, very similar in nature. The big thing was Defense Production Act. The other thing I would say is just how it was framed. So the Biden executive order was all about safety and about protecting AI use, whereas the Trump administration executive order, which was called the Action Plan, was all about competition with China. So the competitive, just the rhetoric of them is very, very different. But I think it's still kind of limited on what exactly they can do, and they're very, very similar in kind of in results, interestingly enough.
Oh, this is all real interesting and significant. And I think we're all worried about China. I think you started to touch on that. What's
Yeah.
it like there? Are they regulating this? Do they have different provinces versus the Communist Party that gets involved like we are? How are we going to fare with that?
That's actually very astute. Yeah, the Chinese system, I've been trying to understand it. I've been spending as much time trying to learn as much as I can about the Chinese system, really since COVID. I think there's a pretty big distinction. They have followed. I think that the way to think about this is that in the United States, we focus a lot on artificial general intelligence, right? That's partly the reason why there's a lot of discussion about safety, because all the big AI companies are really trying to push for a system that would be considered an artificial general intelligence, an AGI, right? That's not really the focus of China. China, when you look at their documents, and I would highly suggest reading I think it was the People's Daily, where they actually, like, everything's in English. They say very, very explicitly what they're doing, and it's very interesting to read every once in a while, read what they're saying about these things. The way that they understand AI is much more of like an industry, kind of an industry multiplier, right? That they don't see it as this race to AGI. And in fact, in most of the documents, you will never see an AGI or artificial general intelligence as the comment. What they see is implementing AI in manufacturing, implementing it in semiconductors, implementing it within telecommunications. And then they also have a very explicit exportation understanding. So they very much want to export their ideas and their use cases to other countries, particularly into Africa is a big one that they've been pushing for recently, and also within their own region. But I think that the perception, especially of the Chinese, is that because we're so focused on really the most advanced tech, they feel like they can kind of let us make our own mistakes. And then, they're actually, a lot of their regulatory bodies are actually very risk adverse. They do have an AI regulatory system. It kind of looks similar, but it doesn't have really any of the safety provisions. And, who really knows what it's going to look like as far as bias and implementation, because those things in the Chinese context just look very, very different. But I think what's interesting about China is they really do want us to be making the mistakes first, and they really are kind of taking whenever you see something that's going on in the United States, usually China is behind us 6 months. And I also think that it's not well appreciated that China's implementation is just at a different level, right? They talk a big game about AI implementation, and there's some really important leaders, but they're constrained on a whole bunch of ways, right? They're primarily constrained on semiconductors and data centers, right? We've restricted chips, and because we have restriction on chips, they can't really build the data centers that they probably would want. But I also don't think that the demand on the Chinese consumer side is as large as everyone thinks that it is, right? I think the best way to think about this is, I forget, I think it was Greg Ip, he, former Washington Post writer, writer in the Washington Post. He does economics. He suggests that 5% of what the Chinese economy is doing is leading edge. The last 50% is just a nutcase, right? And I think that's actually very indicative of what's going on in the economy. 5% is incredibly advanced. There's about half of it that is really got a lot of problems. And that 5% can do a lot of really important work. The other thing I would suggest, as I've been suggesting to legislators and to Congress this last week, is that we really do need to keep these lines of communication open. China, and especially some of these advanced frontier companies in China, have done some really, really important work. This is DeepSeek. Happy to talk about this a little bit later. But what DeepSeek showed is actually some of these technologies that have been kind of on the shelf for a little while can be used very, very effectively. That is now just being implemented in the frontier companies. They're using this for better training. So, ChatGPT, a lot of their newer systems are trying to implement some of those tools. And I think it's that as long as we keep those lines of communication open, and I think the Chinese are kind of forced to because of their, limitations on data centers. As long as that continues, I think that consumers, and especially American companies, will continue to benefit in an interesting sort of way.
Okay, other questions? Oh.
Yeah. When it comes to the topic of AI regulations, in general, we think about data privacy, trust, security, all these things. But there are some regulatory blind spots related to human cognitive thinking, and regulation related to the decision-making capacity based on the algorithm results and all. So is this blind spots be taken into consideration when you design any AI regulation policies? Example, right now we have EU AI policy, and then California state law AI regulation, and other policies and all. But we are missing, in recent times, we have studies by the researchers about usage of AI is reducing the cognitive effect of human brain thinking. In that aspect, how do we cover these regulations to address these points?
So that, oh goodness. Yeah, the cognitive question is really, really fascinating because it depends I would say that a lot of a lot of those studies are super, super, super early. And it really does depend on where you're at in the what you might call the educational ladder, right? So for high achieving students in particular, right, it actually seems to do it increases their abilities pretty dramatically. The only really great study on this was looking at high school students prepping for a college, like a Parley Pro college debate session. Their use of AI seems to have actually increased their ability to compete because they understood what was going on. As far as substitution effect is for cognition, that I'll be honest, I'm kind of skeptical of that, to be very, very honest. Those reports, I think, are they're I mean, we really just don't have a lot of great data what's going on in education. And what we've seen traditionally in a whole bunch of other educational opportunities, especially with video, and I know like the internet and online teaching, it basically creates, some students do really well, some students do really poorly, right? It increases that curve. And I think what's interesting about AI systems now is that there's the possibility that we actually could match students with their capabilities for educational opportunities. So that's on the education side. As far as, workers who are using this to basically substitute out their jobs, that also I think is a little difficult to see, because most everything that we've seen so far in consumer support, in productivity when it comes to programmers, and then writing and lawyers, we've seen basically skills, every single skill, almost in every single report, and there's only one that this doesn't exist in, that people who are novices basically are lifted dramatically, right? They're lifted up. The big thing is that people who are on the very, 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 very top end, and I think this is where a lot of people are really focusing on, people who are at the absolute frontier, it actually seems to harm them. So that is actually the case, right? Those studies are actually, the big one that's about this is only about 16 people. So I'm a little bit skeptical of it. It made a lot of waves. It was produced by what's called Metter. It's a very, very well-known AI system, or AI tracking company. So that I'm almost 100% sure that's the one you're talking about. That I think is just, it needs to be understood it needs to be understood on its own terms. The one thing I would say about that report, and I know we're butting up against time, is that what I think is very, very interesting about that report. So again, it only asked basically the best programmers to use an AI system, but then asked them to predict how well the AI system how well that they were doing with the AI system. So after they did all their programming, they did these programming, like a programming study. They said, oh yeah, it boosted me by 20%, when in fact it declined their productivity by 19%. And everyone else then said as well, right, that experts in machine learning and economists said, oh yeah, it's going to boost like 20 to 30%. So it's very, very interesting that people who are even using these technologies that are on the bleeding edge don't really understand how well it is that they're using them. And I think that's actually something that, we were talking about earlier, the reports like that. I think that's like it's a very interesting sort of result. And it's something that over time, as we just get better about this, because again, we're only 3 years out on this technology, that we're going to understand actually, perhaps there's certain ways to teach students, right? And to have multiple, I'm still of the world that I had a whole bunch of multiple, multiple questions. It was just pure numbers, right? Starting off in engineering, it was a numbers game. You did 20 questions, every single week for weeks and weeks on end. And it was just rote memorization. I have a feeling that we're probably going to get back to that as we realize that there really is only a couple ways of teaching education, but there's more interesting ways to get students involved in learning those sorts of programs. Perhaps they could be talking about something they care about or a topic they care about. I found a lot of students, and even, parents are also trying to do this as well, to try to figure out ways to teach their kid in more interesting ways. I wish I had a lot of these tools. I still watch, I watch a whole bunch of these programs online of like stuff that, mathematics and science and computation. Super, super fascinating. And my expectation is that as these tools and systems get better, hopefully we're going to get better on education, but I think the demand also has to be there as well. So